Good evening. This is Laws 12062 Alternative Dispute Resolution. It's week 6 and tonight we're dealing with the question of arbitration. Your assessment is due shortly, and I hope that you're all progressing well with that assessment piece. If you haven't already submitted your work, please have fun with it. It's meant to be an enjoyable exercise, believe it or not. And it's due 11:45 p.m. on Thursday, the 10th of September. We also have a final take-home exam that will be during Monday to Thursday of week 12. So you have an accelerated program in this one. And the take-home exam is, perhaps if I can give you a hint on it, what you'll be expected to do is consider the various ADR alternatives that might be available to a number of different people that might find themselves in difficult circumstances, and part of your job is to identify, perhaps by way of advice or opinion, what is the appropriate way for you to proceed, or for the clients to proceed in terms of ADR procedures. Explain those procedures, give some idea as to why you believe that is the appropriate way to go, and perhaps if you want to be more advanced in your thinking, you might provide some estimates of costs, you might provide some alternatives as to what form of, let's say, mediation, conciliation or arbitration might be appropriate. So you can be quite specific in that regard, and it is an opportunity for you to actually involve yourself as students in the industry by making real contacts with real people that might be able to provide you with assistance, and with their permission they might even say, well, by all means you can recommend us in your mock take-home exam. So that's some idea of what I'm looking for. I'm really not interested, as I've mentioned before, in having you simply recite what arbitration is or what commercial arbitration is all about, but to apply it in a scenario where it might be regarded as one of a number of options for potential clients of yours. So are there any questions before I go further about the practical assessment, which is due on the 10th of September, or the written take-home exam, which will be finally due on the 8th of October? Any questions about that? All right, well, let's proceed. So tonight we're talking about arbitration, and what you may have noticed firstly is that the text is out of date. So don't rely on the text. It makes reference to the Commercial Arbitration Act as it was, but that has been replaced. And if you've done your reading, you would have come across the concept of the uniform legislation, which in Queensland is the Commercial Arbitration Act of 2013. So the idea of the uniform legislation is to enable the states to have that degree of uniformity, which is seen as advantageous in commercial disputes, in circumstances where the Commonwealth was unable to specifically legislate or pass laws in relation to commercial domestic commercial arbitration. So,
John, could I just
yes, John?
butt in there? Is this act unique in that respect?
No, there are other instances of that type of uniform legislation. Offhand, there was uniform laws in relation to well, perhaps the civil procedure, various pieces of consumer legislation. We do have common pieces in that regard. There was the corporations legislation was also uniform. So it does come about from time to time. Sorry, I'm not giving you very specific information about that, but it is something which is used from time to time. De facto relationships, yeah, I'm not sure, are they totally uniform, Brad? I think there's a lot of it.
Well, they are, well, except for Western Australia, they've remained isolated for the moment, but now most of the states have given over their de facto relationship powers to the Marriage Act, or the Family Act.
Okay, thank you very much, Brad. Appreciate that. I guess there are other instances where the legislation might be uniform in different states, but not necessarily all of the states. For example, the criminal code in Queensland is very similar, if not identical, to the code as it appears in Western Australia from memory. So there are some instances of that. So thank you very much for that, John. And thank you, Brad. Appreciate that. What you may have noticed is that in the Commercial Arbitration Act, there's a reference to the model law. And the model law that we're talking about is something which was created through the United Nations Commission on International Trade, UNCITRAL, UNCITRAL, which created this model law on international commercial arbitration. Originally in 1985, it was amended substantially in 2006. And just quoting from the UN Commission on International Trade Law website, it says the model law is designed to assist states in reforming and modernising their laws on arbitral procedure so as to take into account the particular features and needs of international commercial arbitration. It covers all stages of the arbitral process, from the arbitration agreement, the composition and jurisdiction of the arbitral tribunal, and the extent of court intervention through to the recognition and enforcement of the arbitral award. It reflects worldwide consensus on key aspects of international arbitration practice, having been accepted by states of all regions and the different legal or economic systems of the world. Now, the reason that I'm mentioning that is, firstly, you will see a reference to the model law, so that's where it comes from. So worthwhile having a look at that UN website. The second is that at an international level, you can see the importance of having uniformity in arbitration laws. And I guess it's pretty obvious why. Arbitration applies in typically a commercial setting, albeit that under our legislation it's called a domestic commercial setting. So it's really a commercial type arrangement, which means we're dealing primarily with businesses, we're dealing with companies, and of course businesses and companies aren't necessarily going to be constrained by their activities within a state. So there are substantial advantages in having the same system that applies across the states in Australia, and of course between different states used in a different context there, that is countries around the world. So that's why the arbitration laws which we see in the Commercial Arbitration Act of 2013 make reference to the model laws. They're not exactly the same as the model laws, but they do make reference to the model laws in terms of the way the Act is put together. So you'll see that in the definitions. So I mentioned that in our Constitution, the Commonwealth has power to make laws in relation to conciliation and arbitration, but only in relation to the prevention and settlement of industrial disputes, which go beyond the limits of any one state. So that's the Constitution, section 5135 XXXV. So even back at the time of the Constitution, there was this reference to arbitration. That was then enacted in the Conciliation and Arbitration Act of 1904. We talked about that last time, and it's flowed through. But there was no power for the Commonwealth to make laws in relation to arbitration beyond industrial disputes. So that's why the collective states, in conjunction with the Commonwealth, have come up with this uniform system, which I think is a very good idea. So in Queensland, we have the Commercial Arbitration Act of 2013. That's our version of the uniform legislation adopted by states and territories. Okay, so if we look at that Act, which is pretty important, the Act applies to what's called domestic commercial arbitration. And a domestic commercial arbitration is one where the parties to the arbitration agreement have, at the time of concluding that agreement, their place of business in Australia, and the parties have agreed that the dispute, or which may arise or has arisen, is to be settled by arbitration. So what do we get from that? Well, firstly, the concept of the arbitration is linked to commerciality. It's linked to domestic in the sense that I've used it. domestic geographically, not domestic in terms of, a domestic as opposed to a commercial dispute. And it's also linked to the concept of an arbitration agreement. So that's important, that the arbitration is something which comes about essentially voluntarily from the parties. So arbitration for the purpose of the Act means any domestic commercial arbitration as defined. I guess it's fair to say that the concept of arbitration is to use it as an alternative to litigation in the courts. And it's also fair to say that arbitration is the closest thing that we have to litigation proceedings through a court. But because the matters are to be determined through the arbitral tribunal, that doesn't mean the court has no jurisdiction. So it is possible to impose upon the Supreme Court, which has certain functions to deal with arbitration agreements, for rulings where necessary. Now, given that the whole idea essentially of arbitration is to speed the process, make it less costly, provide the parties with additional power to conduct their own process, it would seem that any involvement of courts by intent should be kept to a minimum. And even then, there's provision for the parties by agreement, either in the agreement that they've signed or by supplementary agreement, to actually introduce the district court as the court to oversee the matters in dispute instead of the Supreme Court, thereby saving some money and in all likelihood speeding the process as well. So Section 6 of that Act says the parties can bring in the district court instead of the Supreme Court if they wish. So Section 7 outlines the definition and form of the arbitration agreement. It must be in writing and it must be in a form of an arbitration clause in a contract or in a separate agreement. So it's a very broad definition. So a very simple contract or even a clause within a commercial contract could be sufficient to have this matter of a dispute or a potential dispute in the future referred to arbitration. I guess the question then becomes, all right, well, if the parties have agreed that any dispute in the future that may arise should be referred to arbitration, what involvement does the court have to actually deal with the substantive matter? I've mentioned that it has power to make rulings in relation to perhaps procedural matters. And Section 8 provides that before a court which has an action in a matter the subject of an arbitration, it must, a court before which an action is brought in a matter which is subject to an arbitration agreement must, that is if the party so requests, refer the parties to arbitration unless it finds that the agreement is null and void, inoperative, or incapable of being performed. So what that tells me, quite clearly, the Act is saying that the courts will not deal with the matter if the parties have come to an agreement which is legally binding and capable of being performed. Then the courts will simply say, this has got to go to arbitration. Don't come here. All right, so what triggers an arbitration in the first instance? Well, again, it's pretty simple. Unless the parties otherwise agree, the arbitral proceedings in respect of a particular dispute commence when the respondent, when one party receives a request for that dispute to be referred to arbitration. It's as simple as that. I request that this matter proceeds to arbitration. That's it. The process has been triggered. Now, once the process has been triggered, I mentioned that the courts do have power to make certain orders, and that's referred to in Section 17 of the Act. We call these interim orders. Not only the courts, but also the arbitral tribunal has power themselves to make orders, and that's in Section 17. So it's quite broad what the arbitral tribunal can do, but if you look at subsection 3 of Section 17, it actually provides some specifics about what it is that the arbitral tribunal can do. The tribunal can make orders in relation to security for costs. Does anyone know what security for costs is? So this is, so just so to put this in context, we're now talking about the arbitration has been triggered simply by one party giving notice to the other that this matter is now referred to arbitration. It's as simple as that. The arbitral tribunal can now make some orders about the conduct of the proceedings, and the first one is the tribunal can make an order as to security for costs. Does anyone know what that is?
Would that be taking...
Yeah.
Oh,
No,
Brad?
no.
No, you're right, Brad.
so either party would need to make a deposit of it could be cash. They have got cash. Can the court ask for another type of security?
Yeah, essentially. Yeah, essentially, you're right. It's it is as John described it, a deposit, if you like. Yep, it's a requirement to ensure that funds are paid. Usually, we only see security for costs in a court context, but what's interesting about this is that the tribunal can make that sort of order. Tribunals, arbitral tribunals, are really very close to courts in that concept. All right, the next thing is discovery of documents. Does anyone know what that means? Discovery of documents and interrogatories.
Yeah, don't get everyone produce.
Yes, Tony. Yep. So documents can be produced.
Everyone produce. Yeah.
Thank you very much. Any other thoughts?
Interrogatories, their request for further information.
Yes, thank you very much, Catherine. That's right, gathering evidence. So it's all about that procedure of disclosing documents and answering certain queries that may be raised. The tribunal can, as a preliminary point, make a ruling in relation to the question of giving of evidence by affidavits. The next is that they can make rulings in relation to inspection of property, which form part of the subject matter of the dispute, taking of photographs, taking of samples, or, and this is really interesting, I like this one, from the outset the tribunal can make the arbitration a stop clock arbitration, which means that the parties are to strictly adhere to time allocated between them. And I think that's a really good thing to do. So if you're giving advice to someone in relation to a potential commercial arbitration, you might give thought to whether it's appropriate to make any of these interlocutory applications for some of those interim orders that could be made by the tribunal itself, and whether you should advise your client to consider a stop clock arbitration. Yes, Benjamin, how are you? Can you hear us there, Benjamin? All right. Are there any questions so far? Let's put you on gallery view. All right. Good. It's good to see a good roll-up, so thank you very much for coming along. Okay, there is the issue of the conduct of the arbitral proceedings. Have a look at sections 18 to 27. That's inclusive. That deals with the issue of how the proceedings are to be conducted. There are some important points. The parties are to be treated equally. What that means is that they must be given a reasonable opportunity to present their case. So, to my mind, those words bring in concepts of natural justice. A party must have an opportunity to present their case. The rules of procedure are to be determined, the place of the arbitration is to be determined, etc. Ultimately, when the decision is made by the arbitrator, it becomes what we call an award, and that award can be legally binding and should be legally binding. But I guess it's fair to say that the process of arbitration is very similar in many ways to the process of litigation. However, it is advantageous for a number of reasons. So I suppose, why would you, in what circumstances would you think it appropriate to recommend to a client an arbitration? Are there any thoughts?
Employment issues.
Okay, yep. Arbitration, and that's specifically in the legislation, so thank you. John says less formal, and I think that's a good thought. It's still a very formal process, of course, and it's the most formal of the ADR processes that we'll talk about. Lower costs. I think that's a really important point, because if we're talking about arbitration in a commercial context, and we're talking about large-scale disputes, then the costs can really be quite horrendous if the matter proceeds, say, through the Supreme Court or the Federal Court. So very substantial saving in costs. Is there a likelihood of the matter being settled without the matter going to court? Yeah, thank you, Tony. It does provide an opportunity for the parties to resolve the dispute more quickly in circumstances where they're not necessarily making the agreement themselves, but they are submitting themselves to the arbitration process. So if there's a likelihood of the dispute being settled, then it might be seen as a great advantage to proceed on that basis. All right, so is it fair to say that most arbitration relates to business disputes rather than private, says John? I think it is. I would suggest that that is the case. And part of the reason for that is that we're talking in this context about the word commercial. So we're talking about domestic commercial disputes. Catherine says there might be more opportunity for parties to discuss the matter. Yes, and the process of the arbitration can provide the parties with a greater degree of control. Also, from the outset, you know, there was notes in section 17 about seeking orders to obtain samples or to take photographs or inspect any property. So we're really getting down to the nuts and bolts at a very early stage in that context. Right, I'd just like to mention a few things about the decision-making approaches that could be used by an arbitrator. And I guess it's fair to say there are a number of different steps that an arbitrator might consider in the same way that a judge or magistrate might consider the steps. The first is that it's a matter of defining the objective, what is actually sought. So you need to be clear in terms of, if you're preparing an arbitration agreement, defining what is the ultimate objective that needs to be undertaken. Then in an arbitration, in the same way as a court, there needs to be a process of collecting appropriate information. And that's something which could be considered in the context of section 17 that I've mentioned before. Then a decision maker would perhaps consider possible options and then make a decision and then implement and evaluate that decision. So there are various steps that might be undertaken by an arbitrator during the course of an arbitration hearing in the same way as a court. Okay, where your text might be useful is in the context of cases. Many of the sections that are referred to in the text, while they've been changed by the new Act, still apply in general terms. So I'd ask you to at least consider those cases which are referred to, and many of them are quite useful in that sense. All right, now are there any questions? Otherwise we'll be probably wrapping up a bit early tonight. And the questions can be about arbitration, can be about the course generally, they can be about the assessment piece that you're currently undertaking or maybe have just completed, or it can be about the exam.
Yeah, John, about arbitrators as a group, how are they made up? Are they legally qualified, or do they just have skills in certain areas?
I'm not, I would say it's fair to say that in this context, they would be legally qualified, but I'm not sure there's any requirement under law that they be legally qualified. And arbitration does provide an opportunity for industry experts to become involved, so engineers, etc., in that sense as well. But that's a good question. Thank you.
John, it's Jenny.
Yes, Jenny?
Just wondering, with the assessment, the words that we have to put with it, and I'm a little bit confused on that, on what it is that you want us to produce in the 500 word count that I read about, or am I confused?
Are you talking about the first assessment piece?
That's right, sorry.
Yeah,
I should have announced that. First assessment piece, yeah.
Thank you. Yes, now this isn't part of what you're being graded upon, so if you choose not to provide any words, that's fine. But what I'd like is for the assessment to be in the form of an audio-visual, uploaded through YouTube, etc. But actually put the link in a Word document, and the Word document is uploaded through Moodle in the usual way. And in that Word document that you use, perhaps if you could put in up to 500 words, and in that, a brief summary of the scenario. Thank you, Tony. And also make a statement as to whether you're acting as a conciliator or a mediator.
Could we, yes, it does, but could we put like a PowerPoint slide at the beginning to introduce the actual mediation? I did see it on something I saw on YouTube, and I thought that was quite effective, where it actually just had PowerPoints stating what the issues were, what the facts were. It was a mediation, it was this and that. Would that suffice as well?
I need to be careful because a number of people have already submitted their work. But what I can say from general principles, I think, and I would have mentioned this, I think, in the first week, be inventive, use different techniques, use different ways of doing things. So I hope that indirectly...
Yeah, no, that answered it. It's an individual thing then, hey?
Absolutely, yep.
Yeah, great.
Thank you, Jenny.
Okay, thank you.
Thank you.
Thanks.
All right. So for those of you that have completed the work, thank you very much. There will be a few people who, at the last minute, find that partners who were going to be helping are not available. So if you're willing to help out a classmate by acting as a participant, then through UCREW, I would suggest, please make yourself available, and I'm sure that you're in all likelihood, people will take you up on the offer. And good on you if you decide to volunteer to help a classmate through that process. Before I finish, has anyone found it difficult to go through that process of uploading their video through Zoom or whatever program you choose to have it available for me? Or conversely, has anyone been through that process and found it pretty easy?
I'm a bit of a computer dummy because of my age. I sometimes have a disadvantage. So my younger colleagues have been leading the way in this, and it's been a pure education for me. So I've got to say now that they've established me, it's quite easy now. But if I'd have gone alone without those partners, I'd have been fairly lost, I think.
Okay, that's good. And the comments that I'm seeing down the bottom are that it was no problems at all. Yeah, it's easy, pretty easy. Even the over 65s can do it. And one says there's hope for me yet. So look, part of the task is to provide you with a new learning experience, and hopefully at the end of the day a sense of achievement as well. All right, so thank you for that.
Thank you for that. John, can I just ask quickly?
Yes. Yes, Sarah?
Just with regards to the final assessment, I've got it down for the 8th of October. Is that correct? That's like a week before exam week.
It is. The final assessment is actually in week 12, and it's a take-home exam. So I haven't tried this before. This is my first take-home exam opportunity, but the intention of it is that it's partly exam, open book, and it's partly assessment. So it's a hybrid between the two, and it's meant to create something of a real-life scenario in that you've got to produce something quickly of quality, but on a strict time limit. And as you may have heard me before mention that I'm very happy for that. I would really like this to be as realistic as possible. So I'd invite you to contact people in the industry. If you think that something should be referred to some sort of evaluative conciliation process or mediation process, then find a suitable candidate to actually be the person that you refer the matter to. Get an idea of costs, get an idea of timeframes, and put that in your opinion. So the whole exam, the whole take-home exam, will be you providing specific advice as to what is the appropriate way to deal with an issue or a number of issues through an ADR perspective. So does that answer your question, Sarah?
Yes, thank you. How long would it? How long will we have to do it?
It will be released, I think, on the Monday from memory, and it'll have to be in by the Thursday. Now, I don't want to contradict anything I've already said. Access to the paper from the Sunday, the 4th of October, and it's to be uploaded by late on Thursday, the 10th of September. Sorry, the 8th of October. So you'll have about 4 days. Thank you.
John, it's Audrey.
Yes, Audrey?
With regards to giving advice about services, is the take-home paper going to have a context of Queensland? So, or is it just assumed that it's anywhere and we can give advice? They're coming to us and we give it to them in our own geographical area?
Absolutely. I'd prefer it if it was in your own geographical area so that it's more meaningful and useful for you. So if you want to make reference to people in Victoria or wherever it might be, then that's fine. And feel free to use the legislation and practices and procedures of that area. So thanks very much, Audrey. That's a really good question.
Thanks for that. Yeah.
Okay. Well, thank you very much. I'll just see there's nothing else on the nothing on the chat facility. Thanks very much for joining us tonight, and I'm very appreciative of the discussions that are going on through UCrew. People are really helping each other very well, and I think that's great. So I'll stop the recording now. All the best.